Welcome to the latest high-stakes update in the Lively vs. Wayfarer legal saga. If you've been following the breadcrumbs of this Hollywood meets the bench drama, you know things are reaching a boiling point. But according to a recent deep dive, we might be just days away from a massive dispositive motion bombshell that could change everything. Why is everyone so anxious? And what does a random date in March have to do with the future of this case? Let's peel back the curtain on the legal strategy that has the industry buzzing. Right now, the legal teams for both Blake Lively's side and the Wayfarer entities are living in a state of professional purgatory. It points out that the parties are actively preparing for trial without knowing which claims are going to proceed. Think about that for a second. In a standard lawsuit, you might start with a dozen different legal complaints, breach of contract, emotional distress, various torts, but not all of them survive the dispositive motion phase. This is the moment where the judge looks at the pile of evidence and says, this claim is valid for trial, but this one is going in the shredder. For the parties involved, this isn't just a minor detail, it's the difference between a 2-day trial and a 2-month media circus. Imagine the stress of preparing a defense for 13 separate accusations, only to find out 10 of them were thrown out at the last second. It's a legal minefield, and the clock is ticking louder than ever. But as the pressure mounts, a specific deadline is looming on the horizon like a dark cloud. Do you know what happens on March 27th? In the world of law, dates are everything, and March 27th, 2026 is the date currently circled in red on everyone's calendar. This is the deadline for filing motions in limine. Now, if you aren't a law school graduate, motion in limine sounds like a fancy brand of bottled water, but it's actually a powerful legal tool. These are motions filed right before a trial to ask the judge to exclude certain pieces of evidence or testimony from ever reaching the jury's ears. It's the hush-hush phase of the trial. The problem? You can't effectively argue to exclude evidence if you don't even know what the trial is about yet. If the judge hasn't ruled on the dispositive motions, the ones that decide which claims stay or go, the lawyers have to assume everything is going to trial. This leads to what we call over-lawyering, filing dozens of extra motions just to cover their bases. We argue that it is in the best interest of the court to release an order before this date to prevent a massive paperwork headache. If the judge clears the air now, the lawyers can stop fighting over evidence that might not even be relevant anymore. If you were the judge, wouldn't you want to clear your desk before the chaos starts? But wait, what happens if the judge misses that window? The messy middle ground and the April 3rd safety net. Legal experts are currently playing a game of will he or won't he regarding Judge Louis J. Lyman. While there's no official rule saying he must rule by the 27th, the logic for doing so is overwhelming. However, there is a second safety net date, April 3rd. This is when the parties have to file their oppositions to those evidence-blocking motions. If the court can't get the order out by the 27th, getting it out by the 3rd would at least stop the parties from fighting unnecessary battles in their responses. But as we warn, waiting that long gets really messy. Imagine trying to parse through a legal document that says, this evidence should be left out because of Claim A, B, and C, only to realize Claim B doesn't exist anymore. It's like trying to bake a cake with a recipe where half the ingredients are being deleted while you're stirring the bowl. So, the big question remains, is the judge going to play it safe, or is he working overtime right now to beat the clock? Judges hate unnecessary paperwork just as much as we do. By issuing the order early, the judge effectively cuts his own workload in half by eliminating irrelevant motions before they even land on his desk. For fans of the case and digital creators following the drama, this means we are in the calm before the storm phase. The decision that determines the entire future of the Lively vs. Wayfarer trial is likely sitting on a desk right now, waiting for a final signature. We are standing on the edge of a major shift in one of the most talked-about celebrity legal battles of the year. Once that order is signed, the guessing game ends and the real battle begins. What do you think? Will the judge release the order early to save everyone the headache, or are we headed for a messy April? Drop a comment below with your thoughts. Do you think the case will be narrowed down, or is everything going to trial? Share this with someone who is obsessed with the Lively vs. Wayfarer drama.